The Supreme Court has taken motu cognizance of reports concerning a controversial speech by Allahabad High Court Judge Justice Shekhar Kumar Yadav. Controversy arose from his remarks during an event organized by the legal cell of the Vishwa Hindu Parishad. Justice Yadav stated, "This is Hindustan and this country will operate according to the majority living here. This is the law. The law itself works according to the majority," emphasizing his views on the Uniform Civil Code and criticizing practices such as polygamy, halal, and triple talaq within the Muslim community. Following his comments, the Campaign for Judicial Accountability and Reforms wrote to Chief Justice of India Sanjeev Khanna demanding an internal investigation. Prashant Bhushan and others alleged that Justice Yadav's remarks were derogatory towards a specific community, undermining the dignity of his judicial position. The Supreme Court has requested detailed information from the Allahabad High Court to determine appropriate action in the matter. The Supreme Court has raised significant concerns about the central government's policy of free ration distribution, questioning how long such distribution will continue and why efforts to increase employment opportunities are lacking. The government informed the court that under the National Food Security Act of 2013, rations are being provided to 81 crore people either free of cost or at subsidized rate. In response, a bench comprising Justice Suryakant and Justice Manmohan remarked that the system benefits everyone except taxpayers. The issue pertains to the provision of free ration cards to migrant workers and unskilled laborers registered on the e-Shram portal. The Supreme Court is hearing the case to address the challenges faced by migrant laborers during the COVID-19 pandemic. Advocate Prashant Bhushan urged the court to direct that all registered workers be provided free ration. Earlier, the court had instructed states and union territories to issue ration cards to all eligible individuals under the NFSA by November 19. However, the central government stated in its response that it can only meet the obligation mandated by the NFSA and cannot issue ration card beyond the limits set by the law. The next hearing is scheduled for January 8th. The Supreme Court has explicitly stated that reservations cannot be granted based on religion. The statement has made in a case challenging the Calcutta High Court's decision to revoke OBC status and reservations granted to several castes in Bengal since 2010. The matter was heard by a Supreme Court bench comprising Justice B.R. Gavai and K.V. Vishwanathan. Senior advocate Kapil Sibbal, representing the state government, argued that the reservations were based on backwardness, not religion. However, the High Court had ruled that classifying 77 Muslim community groups as backward appeared solely religion-based. It subsequently annulled reservations granted to 77 groups under a 2010 order and to 37 groups under later act. Acknowledging the gravity of the issue, the Supreme Court scheduled a detailed hearing on January 7th. Meanwhile, Kapil Sibbal contested the High Court's decision, arguing it impacted the rights of thousands of students and job seekers. He urged the court to stay the High Court's order and provide interim relief. The Kerala High Court is expected to provide interim protection to residents of disputed Waqf land in Munammaba, Kochi. This observation came during a hearing on a petition where residents claimed their ancestors had purchased the land from Farooq College. The dispute arose after the land was designated as Waqf property in 2019, with claims it had been donated to the college as Waqf in 1950. The petitioner challenged the Waqf Act of 1995, arguing it is discriminatory by granting Waqf properties special status, exempting them from standard property laws. They contended that, unlike other trust and religious properties governed by normal sealing laws, Waqf properties can be reclaimed indefinitely under Section 107, which allegedly grants excessive power to the Waqf Board. A bench comprising Justice Amit Rawal and K.V. Jayakumar described the issue as a property dispute and advised the petitioner to file a civil suit. The bench indicated it might impose an interim stay on the residents' eviction, though no formal order has been issued. The case is scheduled for further hearing on December 17th. The Telangana High Court has revoked the Indian citizenship of former PRS MLA Chinnamaneni Ramesh, declaring him a German citizen. The court ruled that Ramesh's action had undermined the electoral rights of Indian citizens. Additionally, he was fined Rs 30 lakh for concealing his German citizenship and misleading the judiciary. This issue surfaced after the Union Home Minister had already cancelled Ramesh's Indian citizenship, a decision later upheld by the court. Ramesh had acquired German citizenship in the 1990s after moving to Germany, where he worked, married, and settled his family. His lawyer V. Rohit argued in court that Ramesh continued to hold a German passport and citizenship even after obtaining Indian citizenship in 2008, leading to the legal controversy over his status. Watch our special programs and share the videos to stay updated with the daily court proceedings.